Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. The Supreme Court today on 18th of May stayed the ban imposed by the State of West Bengal on the screening of the controversial film, The Kerala Story. The matter has been posted for hearing in July 2023 by a bench comprising CJI DY Chandrachud, Justice PS Narasimha and Justice JB Pardiwala. As we know, the Kerala story has raised quite a huge controversy, resulting in some states banning it and many people opposing the conceptuality of the movie. Recently, the West Bengal government banned the movie, considering it to disrupt peace in the state because, as per them, the film contains hate speech and manipulated facts, which can hurt communal harmony and disturb the law and order situation. Allegedly, there is also a shadow ban on the film in the state of Tamil Nadu. As a result of such approach of the states towards the film, the producer of the film, Sunshine Productions, has approached the Supreme Court, challenging the ban imposed by the state of West Bengal against the movie and the alleged shadow ban in Tamil Nadu. On the other hand, many individuals have challenged the refusal of the Kerala High Court to stay the exhibition of the film, and the Supreme Court is considering those petitions as well. Let's take a look into the arguments and submissions made by the lawyers in order to get an idea of the concerns of both the sides. To begin with, Advocate Harish Salve, appearing for the producers, told the court that the other side has said that someone reported today that he watched the film and presumed that people may become violent and create trouble, and 13 incidents have been reported. He said that they are talking about 13 people who have watched the movie and using it to decide that the ban on the movie is justified. Moreover, he said that in Maharashtra there was an incident, but there is no ban in Maharashtra. It is running fully in all the cities, Bombay, etc. The state of Maharashtra has no issues, so why should West Bengal be concerned about Maharashtra? He said that an incident happened in Maharashtra and they dealt with it. With regard to the shadow ban in Tamil Nadu, Mr. Salve said that people are being called and told that the film should not be shown. He requested the court to issue a direction that Tamil Nadu provides all security measures, which they already have professed. He said that there is valid certification by CBFC, and whether the challenge to certification order should be heard, that the court shall decide. He mentioned that both Kerala and Tamil Nadu courts have declined the stay. He also said that the ban is against the valid certification, even though the certification is not an appeal. Mr. Salve then cited a Supreme Court judgment which was against the unofficial ban imposed by West Bengal government on Bobi Shauter Bhoot. He said that it cannot be said to hurt the sentiments of people because it's mere exaggeration, and exaggeration, whether in written work, painting or anything, is entirely a part of creativity. Meanwhile, he also cited examples of more cases such as FA Picture International versus CBFC and judgments pertaining to the film Arakshan, etc. Then he spoke in respect to suspending the screening of the film and said that the state and the center provide conditions for the same. Now the emphasis was shifted to the disclaimer. He told the court that the film was inspired by true events as narrated by victims and their families in their video testimonials. The film does not claim accuracy or factuality of events. On the other hand, senior advocate Dr. A.M. Singhvi, appearing for West Bengal, said that this contention was not true at all. He said that the public emotion is being dealt with, in response to which CJI DY Chandrachud said that if the movie is shown to any 13 people, they'll say ban any movie, and as such a handful of people cannot be taken as a reference for something like this. Mr. Singhvi also said that the order of the West Bengal government was a public order and a preventive power with the state government. With respect to Arakshan, he said that Arakshan was pre-screening, but the movie in question at present is post-screening. And then in relation to the disclaimer, he said that it makes the film worse because it says inspired by true events 2 times. He asked the court as to how is that a disclaimer. He said that these are clever legal words. The CJI finally said that the movie is released all over the country and demographic cannot be expected to be the same everywhere, and as such the power is to be exercised in a proportional way. To this, Dr. Singhvi said that Paschim Bengal's demographic is very different and that has to be considered. The CJI said that the fundamental rights cannot be curbed on the basis of public emotion, and if one does not like the movie, they can choose to not watch it. Meanwhile, senior advocate Kapil Sibal pointed out that the movie in itself contains elements and sections where Muslim men are shown to be perverts, and the dialogues also indicate the purpose for which the film was made. He said that when we talk about freedom of speech, the reasonable restrictions are also to be taken into consideration. With respect to the figures of 32,000 women mentioned in the movie to have been converted into Islam forcibly, the CJI asked Mr. Salve that the figure 32,000 is distortion of facts and should be looked into. In addition to these aspects, senior advocate Huzaifa Ahmadi contended that although it is said that the movie is an act of fiction, but it starts with a statement by a Muslim man saying fight the non-believers. And the other scene shows Muslim clerics talking about how they can lure Hindu women, take them away and impregnate them. He said that in order to generate hate in the minds of Hindus for Muslims, the movie shows a man making derogatory remarks against Shiva and Rama. Finally, the CJI said that they will first have to watch the movie to be able to contextualize it and then decide accordingly. He said that the government of West Bengal has prohibited the exhibition of the film under the West Bengal Cinema Regulation Act 1954 and it is not tenable. The order of the Additional Secretary of West Bengal shall remain stayed. He said that since the counter affidavit filed by the state of Tamil Nadu states that the screening of the film has not been directly or indirectly prohibited within the state, additional security can be provided for every cinema hall and requisite arrangements can be made for moviegoers who want to see the film, and no steps shall be taken by Tamil Nadu or its officers or instrumentalities including the police to prevent the screening of the film. Towards the end, the CJI told Mr. Salve a few important things. 1. There has to be a proper disclaimer in the film. 2. Disclaimer should say that there is no authentic data regarding the figures of 32,000. 3. A disclaimer saying it is fictionalized should be added. Mr. Salve agreed on the terms and said that an additional disclaimer shall be added and it will be mentioned in the disclaimer that there is no authentic data available. That was all about it for today. We hope you like our content. If you do, please like and share. Also subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.